can finish on time. Thank you everyone for joining us during your lunch hour today. On behalf of the ACC board, I want to welcome all of you here. I want to offer a special thank you to Allen Matkins, who is the sponsor for today's event, and in particular, Heather Riley, who's a partner here in Allen Matkins' San Diego office, who is going to take us through a Ceqa 101. Heather, I assume this series goes up to like 901 or something ridiculously advanced, since Ceqa always seems so complicated, but looking forward to getting the intro class at lunchtime today. So with that, Heather, feel free to take it away.
Hi everyone, 901 is probably not even covering the basics. So my goal today is to give everybody just a little bit of knowledge, enough so that you can recognize when there's an issue and raise your hand and ask for help. So I'm going to share my screen. I have some slides. I'm going to be very upfront with you guys. I actually use these slides to teach a 3-hour course at USD. So I've compressed them as much as I can, and I've slipped a couple out. So I'm going to skip over some general topics, but I've given you the major information that you would really need to understand what's going on with Ceqa. If we have questions, you can stick them in the chat or in the comment box, or you can interrupt me, whatever is easiest for you. But I'm going to get started now. And as I said, this is super high level, and I'm happy to, follow up afterwards, specific projects, specific anything else you might need. So Ceqa is the California Environmental Quality Act. I tend to use that term and forget that not everybody uses that term in the acronym. It's found in the Public Resources Code, and we also have what's known as the Ceqa guidelines. Those are the regulations that have been adopted at the legislature's direction by the Office of Planning and Research, one of the governor's offices. And those guidelines have the force and effect of law. So when you're implementing Ceqa, you're not just looking at the statute, you're looking at the guidelines. And in addition, you also are looking at, sorry about that, you also are going to look at case law. Because Ceqa is so controversial, there are hundreds, if not thousands, of cases over the years that have addressed Ceqa. So I think for the most part, the case law stuff we're not going to talk about today, but I just want to put you on notice that there is a lot of it out there. Everyone's got a different opinion on Ceqa, and a lot of it comes through in these cases. Ceqa's main purpose is to allow public agencies to consider the environmental effects of actions. Seems very basic right there at the front. It applies to decisions to carry out, authorize, or approve projects that may have an adverse effect on the environment. May is italicized, and obviously that's important. It's not that will have an environmental impact, it's may. So it's a very broad section on purpose. Ceqa applies to lead agencies and responsible agencies, and we'll talk a little bit about that in a minute. The most important thing that I want you to remember if you walk away from this class today, this session today, is that the goal of Ceqa is not to save the environment. The goal of Ceqa is not to prevent all environmental potential harm. The goal of Ceqa is information disclosure and transparency, period. As long as the information is being put out there in a very straightforward way, then Ceqa has done its part. It is not to, this is such a pain, I don't figure out how to turn these off. It is not to turn off environmental harm. It is not to prevent environmental harm. It's to make sure that the information is disclosed and that everything is transparent. And so a lot of the time you hear people who are opponents argue that we can't do this because it will do X, Y, and Z. We still can, and we'll talk about today what that means, why you still can. Ceqa is alphabet soup. As I said with Ceqa itself, the acronym, there are a billion, it feels like, short terms that we use all the time when we talk about Ceqa. The ones on the screen are just a handful. It's obviously not all of them. I probably missed dozens that I could come up with off the top of my head. But the ones on the screen are the ones that you're going to hear about most often. Environmental impact reports, EIRs, notices. There's a whole bunch of different notices because, as I said, it's disclosure and transparency. Mitigated negative declarations. The hot button topics are VMT, vehicle miles traveled, often TPAs, transit priority areas. I actually just left the County Board of Supervisors meeting where they're in the process of trying to adopt their VMT guidelines. 2.5 years later than the state wanted them to, but they're trying. So there's 3 important questions you need to know when you're talking about Ceqa. Is the activity a project? Is the activity exempt? And what level of review is required? We're going to take these three questions in steps. And again, just enough so that you have some basic knowledge. There are a billion nuances that come into play with each of these questions, fortunately or unfortunately, depending on, I guess, what side of the line you're on. So here's the CEQA process flowchart. It's not straightforward. It doesn't make sense. It's super hard. For years and years and years, there's always been talk about reforming CEQA. At this point, I just don't see how that's ever going to happen at the state level, because everything is so entrenched and so argumentative about this process. And it has become really difficult as a result of all of the arguing back and forth. But if you sit and study this, you can determine your path forward. It's just, it feels very up and down, back and forth, 2 steps forward, 6 steps back. So the first question is a project activity a project? So I've highlighted and underlined the terms that are defined terms to the extent that these terms can be defined. So as it says on the screen, discretionary approval by a public agency that results in a direct or indirect environmental impact. Discretionary is one of the key terms of CEQA. If your action is ministerial, CEQA does not apply, period. You're free and clear. You don't have to worry about it. Ministerial or administrative decisions that require the application of fixed standards. So building permits, right-of-way permits, parcel maps are considered ministerial in almost every jurisdiction. Final maps, ministerial. It means there are standards and you have to meet those objective standards. Discretionary, on the other hand, means that there is some exercise of deliberation. Someone who's your decision maker is going to consider if your project fits. Some of that is subjective, some of that is objective. There are mathematical formulations that may come into play, but there's also sort of feelings that come into play. Discretionary, for those of you who are familiar with the City of San Diego, City of San Diego has 5 levels of process review. 1 is ministerial, building permit, no CEQA. 2 through 5 are all discretionary levels of approval. They just have varying decision makers at the end of the process. So if you're a 2, you're seeking a simple permit, your staff is going to make your decision. If you're a 5 and you're going for a full rezone, a plan amendment, a big, huge project, the city council is your decision maker. But all of those 2 through 5 means you have to consider CEQA. This is discretionary. Approval is the second term. Approval means that the agency is committing itself to a definite course of action, and timing is super critical. There's a really famous case from, about 20 years ago now, called Save Terra, that came down and that talked about this particular issue. How soon is too soon? How late is too late? And Save Terra was about a project up in LA. It's an old building that looked like Terra from Gone with the Wind. And there was a lot of angst over an MOU, a memorandum of understanding that had been signed with one of the public agencies. Did they have to do CEQA to do that MOU? And so that question comes up way more than you would think. It should be straightforward, but unfortunately it's not. So the agencies can't be committed, but they also can't be too uncommitted. There has to be some level of, we're in this, but not so far in this that we can't change our mind. And I know that sounds ridiculous, but unfortunately, that's the rule that has come into play. So the second question, if you are a project, and I will often say capital P project, and my associates and other people laugh at me, a capital P project, as you saw on the last screen, is a defined term under CEQA. So a development project, just in general, is not the same as a capital P project for purposes of CEQA. So is the activity exempt is our second question. If it's with certainty, if you can determine with certainty that there will be no significant impacts, then you can be exempt. And there's categories and there's boxes and there's types. So the 2 on the screen are statutory and categorical. Statutory means that there's just a box the legislature has determined are clear. Statutory can include a variety of things. The most common we often see are when the legislature decides, most recently, a stadium is exempt or subject to some sort of streamlined, modified exemption. In the past, when the LA Olympics were here in 1984, the legislature cleared almost all of the LA Olympic building from CEQA as a matter of course. Categorical are those that are bigger boxes, but a bunch of stuff can fit in them. They're not project specific or idea specific. Categorical can include, the county wants to put a whole bunch of new parking meters all along the length of Pacific Highway. Well, that could be a categorical exclusion because those individual pieces are not really going to harm the environment, and collectively, cumulatively, they're also not going to harm the environment. You can show that, you can explain that. Categorical also includes small tenant improvements, single family homes often fit in there, and there are some infill exclusions, exemptions that we can talk about later. I want to be clear though, categorical exemptions, are not absolute. The statute, the guidelines, include a specific provision, kind of a carve out. Your location, the cumulative nature of your project in view of a whole bunch of other capital P projects, whether you're near a scenic highway, a hazardous waste, a lot of things can pull you out of a CADEX. And because they call those unusual circumstances, now you have to go through Ceqa. You can't be exempt. There's also another one that sometimes comes up, called the common sense exemption. When I first started practicing 20 some odd years ago, lots of people tried to shove stuff in the common sense exemption. And then there was a bunch of case law and everybody walked away from it because it was really hard. It doesn't show any common sense. It has come back in a couple of places, especially in Northern California, I've learned from our colleagues up there, particularly for housing projects. So I'm curious to see as we move forward in the next 5 to 10 years and this housing crisis continues, whether or not more people try that option again. So now we're on the third question. You are a capital P project, you are not exempt. Now, what level of review do you have to do? So normally the agency prepares what's called an initial study. It's literally just a form, it's a checklist. It tells you whether you have to do a negative declaration, mitigated negative declaration, or an EIR. Generally, the EIR is much more in depth. We'll talk about the contents in a minute, much more robust analysis. Quite frankly, today, most MNDs and NDs are pretty thick and heavy. And if you have any opposition, you don't really want to do an MND, ND, as we'll talk about later. An EIR is usually your best bet if you have opposition and you have potentially significant impacts. As I talked about in one of the first slides, the may question is what matters here. May your project cause a significant impact? Not will it, may you cause a significant impact? That's a really broad, huge ask, right? Because a lot of things could have a significant impact. The definition is on the screen, so you guys can read it. It's physical, it's land, air, water. I mean, it's just kind of the vaguest definition on purpose because they really want to make sure we're being transparent and disclosing all potential impacts. Importantly, under Ceqa, social and economic changes by themselves are not significant impacts. Now, if you have a project that's subject to NEPA, the National Environmental Policy Act, which is the federal version, social and economic changes can be significant. At the state level, they're not. And for about 10 or 15 years ago, there was a huge bunch of Ceqa cases that came out about Walmarts. Walmart was coming in and building these stores, and the argument made by opponents was this was resulting in urban decay. Urban decay is not a category in Ceqa. It's a social economic change, but it could have indirect impacts. So there's a lot of case law that talks about big box stores in the context of Ceqa that are interesting if you're working on anything of that particular nature. The Ceqa Guidelines Appendix G lists the impact areas that are identified first in the initial study and then studied in your ultimate document. Appendix N is a more recent version of the appendix of the Ceqa Guidelines, and that's an infill checklist. It's generally the same. These impact areas are the world of things we have to study under Ceqa. 99.9% of the time, we don't study every one of them. Some of them get screened out, particularly for urban or infill projects. We're not often studying ag, we're not often studying mineral rights. Those things just go off the table. You can also pull some out because of a variety of streamlining options that we'll talk about later. So in the what level of review is required, when your initial study is complete and your checklist is done, you're going to end up with an MND or an EIR. And I've identified the differences between these documents on the screen. A lot of our developer clients always are, well, let's just do the shorter route. Let's just do an MND and take our chances and run the risk. If anybody comes forward, we'll deal with it then. The contents aren't all that much different. The review publicly required, when we talk about that in a little bit, isn't that much different. So if you do have opposition, conservatively, you're probably going to want to do an EIR. because it is a better document in terms of disclosure. It is a more robust disclosure. Some public agencies always want to shove you into an MND because they think it's easier. Some public agencies, I had a conversation with a client the other day, a public agency in Northern California won't do MNDs as a matter of policy. It's an unwritten rule that you can't do an MND in that public agency. You're either exempt or you're an EIR, period. Well, that's contrary to Ceqa, but it's the agency's rules and you're going to try and work around them. In an MND, you have to be able to show that all of your significant impacts can be mitigated. Everything goes away. There's nothing left at the end of the day that may cause an impact on the environment. You don't have to study alternatives, and you don't separately have to study cumulative impacts. You do have to do public review. You aren't required to prepare responses to comments, although you'd kind of be an idiot not to if you send something out for public review, not to respond to those comments and close that loop. You are recommended to do findings, and again, you're going to want to because you want a clear record. The major difference, and you can see the differences between MND and an EIR, the major differences between the two are the first and last bullets. Under an EIR, you can still have significant unmitigated impacts on the environment. You're going to have to do a second step in your approval. The agency is going to have to approve a statement of overriding considerations, which is essentially a balancing document. We recognize these impacts will remain significant and unmitigated, but we also recognize we're going to get benefits, tax dollars, new homes, growth where we want it. Different things like that are often what you see in an SOC. The second, and I think frankly more important difference between MND and an EIR is the standard of review. If you end up in litigation, if you end up in front of a judge, that's usually my job. I do the oversight of the Ceqa documents and then I litigate them as well. I would much rather be defending an EIR because the standard of review is substantial evidence. That means the courts are directed to defer to the public agency. I can put to everything that went before that public agency before they made that decision is my world of evidence, and everything is available for me to show a judge, see, we did our job. We disclosed everything. We couldn't quite mitigate everything, but we disclosed everything. For an MND, the fair argument standard is very, very generous to a project opponent. So it's a little more, like a lot more difficult sometimes to defend those in court. Not impossible, but more difficult. So the process for an EIR, which is the more robust process, a notice of preparation saying we're starting this process, a notice of completion you send to OPR when your draft EIR is done, and a notice of availability goes out to the public saying, here we go, here's a document, you can comment on this. Those Appendix G impact areas that I showed you earlier, you're going to study whichever ones are applicable to your project, and you're going to study them based on thresholds of significance. Those are performance level, quantitative or qualitative standards. If you are compliant with that standard, normally you're going to be less than significant. That's the term we use. If you're not compliant, you're going to be potentially significant. You are either potentially significant and mitigated, which puts you down back below less than significant, or you're significant, potentially significant, and you can't mitigate, significant and unmitigated. The Ceqa guidelines has thresholds that the state OPR has offered as baseline thresholds. Lots of agencies, especially smaller ones, simply adopt those. But other ones like the city of San Diego and the county, they have their own versions of thresholds, which usually have some tweaks. The ones on the screen are the ones that come up more often than not, especially in Southern California. As I mentioned, transportation is the hot one. Level of service was how we studied traffic forever and ever and ever until 2020. Now we study vehicle miles traveled. Cultural resources in Southern California, we have lots of tribal lands, lots of potential for finding unexpected information and data in our dirt. Water supply is always important in California, GHG emissions and wildfire. So when we're looking at our significance thresholds, we have to study direct and indirect impacts. Direct are exactly what you would think. Something is happening because of this project. We're removing all the vegetation. We're taking out this habitat, potential habitat for a species. Indirect is something that's not immediately related. It's just reasonably foreseeable. So I talked earlier about urban decay when we looked at those Walmart cases for a while. Would it result in stores going vacant? Would it result in people leaving? Those are indirect impacts, sometimes used for Ceqa, sometimes not. The more common indirect impacts are, would this housing development cause a school to be overcrowded? Do we need new parkland? That sort of stuff. So if you do have potentially significant impact, Ceqa says you have to mitigate it. You have to try and reduce it, avoid it, minimize, reduce it. That's the goal of mitigation. It has to be feasible, which is something we're going to come back to, but it also has to be specific. And one of the problems I often encounter with some consultants is their mitigation is just sort of not great. A mitigation measure has to tell you who is responsible, when the work has to be done, what has to be done, where it has to be done. It has to be very specific. Before issuance of building permit, before issuance of certificate of occupancy, the applicant or the consultant or a general contractor has to do X, Y, and Z. It needs to be very, very clear. It needs to also be enforceable by a public agency. If you have a less than significant impact, no mitigation. I don't care what opponents say. I don't care what public agencies say. You can't make me mitigate something that's already less than significant. That's the law. So as I said, you're minimizing or reducing to the extent you can. Alternatives are required if you're doing an EIR. Ceqa case law and the guidelines and the rules say you have to study a range of alternatives that feasibly, and again, we'll come back to that in one slide, I think, reach the project objectives, which is what you're trying to do with your project, and substantially lessen any impacts. It's hard to come up with alternatives. It's kind of like creative writing, I always say, but it's required if you're doing an EIR. It doesn't have to completely eliminate your impacts. It just needs to reduce them. The reasonable range, I may say 2, an opponent may say 12. The public agency may say 4. It's a guessing game and it's not an exact science. There is a rule of reason in the case law and the statutes and the guidelines, but rule of reason, the reasonable person, I mean, that's just the worst. All of us who are lawyers know that's like the worst term, because it's great when you're trying to say this is enough, but it's also not great because everybody's going to say you haven't done enough. Under Ceqa, you have to study a no project alternative, and that's not always straightforward. A no project alternative may mean that you don't do anything on this site, but it also may mean that you don't do what you're proposing, but you do what's allowed on the ground. So if your general plan says you can build 12 homes here and you're proposing 55 multifamily units, you most likely will have 2 no project alternatives. Nothing, the ground stays vacant. And what does the general plan allow? Those 12 units. You might study that because that's technically what's allowed on the site today. You also have to determine the environmentally superior alternative. It cannot be the no project alternatives. So often what you find, particularly with housing development, which we've done a lot of recently, is a reduced number of units or a reduced footprint. We'll cluster all the units further away from some potential bio, or we'll take 50 units and study 10. Because that gets us below a level of significance for a particular threshold. Now, a public agency, they want those 50 units. They need to meet their housing, their regional housing needs assessment allocation, their RHNA numbers. They want affordable housing that's coming with your density bonus project, but you have to study it because, again, we're talking about disclosure. So here was the slide I referenced. What does feasible mean? Feasible means that you've looked at economic, environmental, legal, social, and technological factors, and you've determined this is possible in a reasonable amount of time. So what is important for my job when I'm talking about producing housing, when I'm talking about developing the One Paseo project, when I'm talking about any of the projects I work on, I actually think infeasible is more important, because the reasons you're allowed to say something is infeasible is there's an economic, social, legal, technical reason that this doesn't work. And as I said, sometimes it's general plan goals. My general plan says I want 50 units here. And I may impact the environment, but I need to meet my RHNA numbers. I want housing near transit. So yeah, it might cause a transportation impact. Yeah, it might put a really tall building where we have a bunch of 2-story buildings today. I'm okay with that. It's infeasible to pick this alternative because I can't take 10 units here. It's just, my policy, my planning documents say I need to maximize development in this location. You can also look at site suitability, economic viability. There's a whole host of reasons you can come up with, again, creative writing to come up with your infeasible findings. But what I would say the most important thing is, as long as you have substantial evidence in the record to support that. A lot of our clients very easily could show that economically they can't make a smaller project work. Most clients won't do that. They don't want to put their financials on blast. They don't want to go out there and show all that information. So you really hardly ever see economics. Once in a while, like on I can think of a project in the last 10 years, there was a historic home that a single family project up in Northern California was going to change. They put their economics out there and said, we just can't keep this house no matter what. Most of the time, though, it's going to be another reason. But no matter what you submit to show that in feasibility, it has to be supported by substantial evidence in the record before the decision maker makes their final decision. The agency has to have a chance to approve it and agree with those statements that you're making. Another important part of CEQA is technical studies. I am not a scientist. I am married to a scientist. I have hardly ever an ability to understand what he's talking about. The last science class I took was in college when they made me for my history degree. I view myself as a translator between the technical experts who are really good at their jobs and the decision makers and the general public. I often say we're talking about a third grade reading level. Thank you, traffic experts. Thank you, air quality experts. But if my third grade kid can't understand that, we're not doing our job. So we have to translate between those two different audiences. But the technical studies have to be very technical, because when I am standing in front of a judge, I have to be able to say those experts know what they're talking about. That is my substantial evidence in the record. Often the experts will propose design measures that we fold in at the front of a project to help minimize impacts later down the road. You might include a traffic signal at your driveway because you know if you don't, they're going to tell you to do it anyway. So you fold it into your project. If you don't, the traffic technical study may say you have to mitigate by including a traffic signal here. Kind of semantics, it's going to happen anyway. It's just a matter of do you put it at the front end or the back end, but the technical experts are the ones that tell us those things. 100% your technical experts need to be involved in, they prepare their document, the CEQA consultant writes that chapter based on that expert report. When comments come in from the public, you want your technical expert involved in preparing those responses to comments because you want the answers to be accurate. Whether or not you get response, like sometimes you get a comment that has a technical expert's report attached to it that rips apart the city's technical expert. The technical expert has to explain why that response is wrong. Sometimes it's lay people who put a lot of mishmash out there. The technical expert should still review those comments and help you put those responses together. And I am adamant with my clients that we want technical experts at public hearings. Yes, it probably costs more, but if somebody on the dais asks a question about transportation and the city staff punts, I don't want to answer that question about how my calculations on traffic on Camino del Sur worked. That is, I can tell you what the answer is. I can tell you what the number said in the chart, but I can't explain how I did the analysis. So you always want to have those experts there just in case. Hopefully they never have to say anything, but you want them there. Public review for an ND or an MND is at least 20 days, 30 days if you're sending your document to OPR, which, to be quite frank, almost everything goes to OPR now in an abundance of caution. So at least 30 days. An EIR gets at least 30 days, 45 if you're sending to OPR. It's only 15 days different. And as I said, if you can stomach putting the alternatives and the cumulative sort of analysis in your document, an EIR is a little more bulletproof, although I generally don't like that term because we can't make anything bulletproof. But an EIR is a little more comforting, I guess is a good way to say it. Your final EIR, after you put documents out for public review and you bring it back in, you have to put together your final EIR. It has to include every comment you've received and every response to those. And it has timelines for how quickly it has to go out before public hearings. Now, importantly, and this is something that I constantly feel like I'm reminding, CEQA never requires a public hearing. There is nothing in CEQA that says an agency has to, in a public forum, consider your document. Your project approval probably requires a public hearing, and at that hearing, the agency will talk about and consider and approve the document, whichever document is presented. But CEQA itself does not require a hearing. So on responses to comments, say you get a letter from a neighbor who's just really angry. They don't want you to redevelop this golf course because they're going to lose their views of, the green on hole 17. They're going to throw a bunch of nonsense in that letter about property values and sites and, all the eagles they've seen there over the years, all of which is probably true. A lot of it is irrelevant to CEQA. but you have to prepare a response to every single comment. Sometimes the response may be, thank you, this will be forwarded to the public decision maker. Sometimes the response will be, this does not raise a Ceqa issue. Sometimes the response will be, thank you, we appreciate your comments on eagles. Our habitat surveys on X, Y, and Z determined this instead. It has to be line by line, almost, which can sometimes be exhausting and can sometimes make my clients absolutely nuts, but you do have to respond. The scope of comment dictates the scope of response. So if it's just a, I hate this project, don't approve it, the response can be, thank you, this will be forwarded to the decision maker. If it's super intense and they've included an expert letter, you need a more intense response in that case. By law, you don't have to respond to late comments. When the public comment period closes, the door is technically closed. Practically, you would again be a fool not to respond to those comments. If you have the time and the ability, putting a written response to the staff report or somewhere else. If your FEIR, final EIR hasn't gone out yet, you can include it there. If it has, then you include it in an appendix to the staff report or some other document. The Ceqa consultant should still continue to do their job. If you're about to send your final EIR out and one of the comments raises an issue that's new, or if something else changes that causes you to potentially have to recirculate, which is a terribly dirty word for my clients, then you need to consider whether that's necessary. Recirculation is new significant impacts, new mitigation measures are feasible, more severe significant impacts than you didn't realize, unless you can mitigate those, or, and this has happened, there's other options, but the final one is the EIR was just so terribly bad that it was not meeting the disclosure requirements of Ceqa. Once in a while, we still see that, sometimes with smaller jurisdictions or one-off projects that for whatever reason just blow up. If your EIR can't stand on its own legs, you need to go back to the drawing board. But if there's a piece that just needs tweaking, you don't necessarily have to recirculate. If you're simply explaining something that was already explained, or you're clarifying something that may have been just misstated, or there's an error, two numbers got transposed, you don't have to recirculate because of that. Your final EIR, there's a reason why you have a draft and a final. The final EIR finishes the document. You are allowed to clarify. You are supposed to explain in response to those comments what other things are important. Project approval and findings. Agencies adopt MNDs and certify EIRs. That's one of those, like every one of us has some sort of pet peeve about their jobs. That's one of those things that drive me crazy when people say you approve an EIR, you certify an EIR. Simply semantics, I know that. But you cannot approve a project either with you can't approve a project with an EIR that has significant unmitigated impacts unless you make findings. Those findings lay out the different things you've done to try to address all of those significant and unmitigated impacts. Changes or alterations were made. You adopted mitigation measures. You picked an alternative. You did something that removed the significant and unmitigated. You have an EIR, but you have a project now that's free and clear of potential impacts. You've made all the changes you can and you're good. Sometimes you can't make all the changes because another agency is responsible. So for instance, the One Paseo project I mentioned earlier, that project sits up in Carmel Valley in the city of San Diego at the northern edges of the city. The traffic that would be caused by that project, that has been caused by that project, some of its effects were going to be felt in the city of Del Mar next door. The city of San Diego couldn't make the applicant fix those impacts, widen the roads in Del Mar, add new traffic signals. They just don't have that authority over Del Mar land. So sometimes you end up with a significant and unmitigated impact because of that. There's some jurisdictional boundary. Caltrans, an impact on a freeway. You can't make Caltrans add another, road lane on the on-ramp. That may end up significant and unmitigated. You could still do the change, and you very well might, but the agency in question, the lead agency, the one that's approving your project, can't guarantee that impact will be mitigated. The third one is there are reasons that something is infeasible. General plan, policy inconsistency, economics, other things like that come into play. And as I said early on, you can still approve a project, an agency can, even when there's a significant and unmitigated impact, as long as a statement of override considerations is adopted. Essentially, you're asking the decision maker to accept those impacts, those significant unmitigated impacts, and say, but we still want this project because of X, Y, and Z. A really important topic of Ceqa that has come up in the last, well, probably I've been here 20 years, 22 years at this point. We've always had some level of streamlining, but it happens more and more and more now as we're moving forward, and the legislature has gotten involved at a much higher level. Ceqa has generally always allowed you to do tiering, which means you have a program EIR, and then you use a document that comes underneath that program EIR, or a master EIR. So for instance, if you're in downtown San Diego, your projects, if they're consistent with the downtown community plan, staff looks at the program EIR that was approved way back when the community plan was adopted, and they check to see if you're consistent with that analysis. They prepare a consistency checklist. If you are consistent with those boxes and those questions, you tier off of that program EIR and you're done with Ceqa. Another option is a subsequent or supplemental EIR. You have a project that's being modified in some way. Maybe you were looking at 50 homes, now you're looking at 55. Maybe you were looking at 25 homes, now you're looking at 10 plus some retail downstairs. You can take the prior environmental document and do a subsequent or supplemental analysis, either an ND, MND, or EIR. There's some substantial change to the project or to the environment around the project, or there's some new information that didn't exist in the past that you now have to consider. Subsequent and supplemental EIRs have specific rules on how you go through this process to determine whether or not you have to prepare this new document. If you do a subsequent or supplemental document, an MD, MND, ND, or EIR, you got to go out for public review, you got to do similar pieces of process, but it's usually much shorter. You're only looking at the things that are changed. You only might have to send out a couple of chapters, not a full document. Alternatively, there are some changes in the project or environment, but no new impacts. No new or more significant, severely significant impacts. You can do an addendum, and we've done a lot of addendums in the past, especially recently, where we have a project that's consistent, for instance, with the Uptown Community Plan and the EIR that was approved for the Uptown Community Plan over in the Hillcrest neighborhood. If you have an addendum, you're saying, we checked and nothing about this changed project is all that different. So we are consistent with the prior environmental review, and here's all the reasons. An addendum is a written document that shows why you're okay. It doesn't have to go out for public review, and it gets approved by a public agency at the same time they're looking at your project. If you can do an addendum, you're in usually a pretty good place. You just need to make sure that your analysis is sound and that all of your information is supported by substantial evidence. Other types of streamlining that have happened in the last couple of years, or become more popular, I should say, in the last couple of years, you can be consistent with a specific community general plan and zoning. And there's a variety of CAT-X's, categorical exemptions, that say if you're consistent with these things, you're exempt from Ceqa. In a way, it's not quite as streamlined, but it is sort of the same end result. You don't have to do a Ceqa document. Infill projects, there's a specific CAT-X that applies to infill projects, and there's a specific portion of the Public Resources Code. Infill project exemptions are definitely a form of streamlining because you're fitting within a box of what's already contemplated on an urban site. There are acreage and other types of limits that sometimes come into play, but if you have a project that's in an urban infill location, you always want to check to see if you can fit into an exemption or there's some type of streamlining that applies. Sustainable communities environmental assessments, which are called SKIAs, are much more common in the LA area than they're down here. I can think of only one project that did a SKIA in San Diego. It's something that we have tried to make work a couple times, but the city of San Diego doesn't love it. They'd rather do an addendum, or they'd rather do an MND, or some sort of combination or an exemption. But if you have a project outside of San Diego and you have a SKIA as a possibility, I highly encourage you to consider that as an option. So judicial review, as I mentioned earlier, there are different standards of review for different documents. I do litigate Ceqa documents, so I am very invested in this half of this portion of Ceqa. When a project is approved, Ceqa says within 5 days, the agency is supposed to file a specific notice with the county clerk to say they've done something, they've approved this project. The 5 days isn't mandatory. Agencies don't always follow it. It's ideal, but it's not always done. But if you get that notice, for instance, if you're doing a notice of a negative declaration, a mitigated negative declaration, an EIR, or an addendum, in fact, you file a notice of determination. That notice of determination goes to the county and tells the world this project has been approved. Any opponent only has 30 days to file a Ceqa lawsuit. At the end of those 30 days, it's jurisdictional. A lawsuit is no longer timely. People may still file it. It's just not going to go very far. If you're doing an exempt project, you file a notice of exemption. 35 days is the statute of limitations. If no Ceqa is completed because you're streamlined or it's not necessary, or you don't have a capital P project, you're not discretionary, you're ministerial, 180 days is the statute of limitations. Much longer than 30, but it's still only 6 months. The reason for these relatively, and in some cases, very short timelines as statute of limitations are because the state recognized that Ceqa is used as a tool for delay. And so they want to pull these lawsuits very quickly. They don't give you a year like you might have for a contract dispute, or years. 30 days, you have to put up or shut up. If you do end up with a lawsuit, it's going to be a petition for writ of mandate. And a petition for writ of mandate means that somebody is asking the courts to intervene to correct an agency's alleged error. The agency screwed up by approving this project. They should not have, because more Ceqa review, different Ceqa review, any Ceqa review was required. Sometimes petitions are combined. You might see a declaration, complaint for declaratory relief attached. But a petition for writ of mandate is the standard form that Ceqa cases are filed in. It's very similar to an appeal in that there are no witnesses, there's no discovery. All of the information that was presented to the public agency on the day that they approve, everything in staff's files, is what your record is, your administrative record. So part of the litigation is putting together that world of evidence and getting it into a format that's easily digestible. Easily is absolutely in quotes. I've worked on projects where our administrative record was 60 large 4-inch binders in a room unto themselves in my office. That was a hugely controversial project. More often than not, your record might be a couple of binders. Sometimes it's 5 or 6, because all of the stuff that came into the public agency, all the comments, all the back and forth, all of the draft documents, not all of the draft documents, but the draft documents that are final that went out for public review, those are in your record. That's the stuff you can cite to in front of the judge. Importantly, Ceqa actions are subject to preference. In reality, that doesn't mean a whole lot because courts are so impacted. You don't really go too fast, but we don't have actual trials. We have motion hearings, really. And so motion days are usually once a week, often on Fridays. So you're competing with all of the other summary judgment motions, motions for preference, all types of hearings that come up in court. In regular civil cases, our trials are heard the same sort of way. So just because you get preference doesn't mean that you're rushing to the front of the line. It just means the courts are supposed to give you some acknowledgement. Now, I say that often a Ceqa case is heard within a year, as long as the record gets put together quickly. As a developer's lawyer, a lot of the times I want to be responsible for that record. So if a petitioner says they're going to do it, I'll very nicely come in and say, don't worry, we'll do it. And my client says, yeah, and you don't have to pay for it. You just have to pay for your copy, petitioner. It's not a great deal necessarily for the client because they're going to be paying my rates, but we know we're going to get a record that allows us to win this case. That is very important. And as I said early on, the most important piece of the judicial review section is the standard of review. An EIR is substantial evidence, deference to the agency. MND or ND, fair argument, a much higher hurdle to overcome. Okay, so that's the end of the slides I have today, and I can't believe I just did that in the time I did it. I talked very fast and I apologize, but if anybody has questions or comments or there's anything anybody wants to share, I'm happy to answer anything. Seeing none, does anybody have any interesting projects that they're working on that this is going to help them direct some work that's sitting on their desk? Ceqa doesn't go anywhere, no matter how the economy is. We're always working on documents. We're always litigating cases. It's sort of a never-ending piece of our practice. So I'm sure there's a lot of you who have come across this pretty frequently. Yeah, I can absolutely share the PowerPoint. I will ask Audrey. Audrey has a PDF of it, so I'll ask that she make sure it goes out to everyone who signed up for this class. I thought the PowerPoint had a lot more information on purpose. I didn't cover every single piece of it because I thought it could be used sort of as a resource for you all moving forward. And I meant what I said at the front end. If you have questions, if you have specific asks, I'm always happy to answer them. The last slide did have my contact information. I'm happy to be a resource to the extent I can. Okay. Well, thank you all. I hope you learned something. And as I said, don't leave with anything except, well, leave with as much as you want, but the most important thing is Ceqa is disclosure. It's not preventing impacts on the environment. Don't ever let anybody tell you any differently. Okay. Thank you, everyone. I hope you all have a good afternoon.